We are very happy that we are such a great and mixed crowd of both international colleagues and clients and interested persons, but also experts from Austria that deal with these topics on a day-to-day basis. And to strike a balance, we try to cover both general information that might be of interest to every one of you, but also go a bit into detail what might be the problems in the upcoming months. So we will kick off with a short introduction and some background on the EU Mobility Directive and the current status of the implementation in Austria. What are the motivations for cross-border reorganizations? What is the current legal situation? So prior to entry into force of the new law, a short overview of the EU Reorganization Act. So that's the new law to come mid this year. Then we will do a deep dive into the cross-border conversion, cross-border merger, cross-border demerger, and we will share with you what we think are the main consequences for our practice or for you in your business day, and we will round up with a short Q&A session. Just a quick comment. I think you see it in the chat box. Please post your questions in the chat field. We will try to answer them on the fly or in the Q&A session, but if we don't know, we cannot comment on it at the spot, or if time does not permit, we will come back to you after the webinar, either via email or by phone. All right, starting with the first item, the introduction and some background. In reorganization laws, the evolution, and I want to emphasize it's an evolution, not a revolution in the last years and also decades. It's mainly driven by EU case law, so by the European Court of Justice and corresponding EU laws. And that's also the reason for this, the EU Mobility Directive, with quite a long name in the second bullet point on the slides. It was a decision by the European Court of Justice in the case Pol But. That was the key factor of this directive. In Pol But, it was a Polish company that wanted to reorganize and wanted to change its seat to Luxembourg, and the key thing was that it was just the corporate seat and not the place of effective management or assets. It was really just the corporate seat. And the Luxembourg court, they registered the conversion, so the change of the seat into Luxembourg, but the Polish register court, they refused to delete the company from the Polish register, and that's why the European Court of Justice has to decide, and the court says, yes, this must be possible, and that's why the Commission and the EU legislator had to make a new directive that needs to be transposed by the member states. The deadline for the transposition was expired on 31st of January this year. Austria hasn't met this deadline. I found a survey dated April this year, and according to this survey, it was only Hungary, Finland, Germany, Sweden, and Estonia who met the deadline. However, Austria published a draft law, or the Ministry of Justice, the competent ministry, in January, followed by a government bill in end of April this year, which is currently in Parliament for the regular legislative process, and it's expected to enter into force on 1st August this year.
Yeah, with regard to tax law, the draft tax laws were published in April, a few days before the government bill on the corporate laws. The government bill on the tax laws was published just a week ago, on the 14th of June. And the tax laws which concern these new rules on cross-border organizations, they are actually set to be to apply for all resolutions taken after the 31st of January of 2023. So even though the Austrian transposition of the directive will be delayed a few months, the Austrian tax law drafters wanted to make sure that, of course, there's always two countries involved, and if the other country has already transposed the rules, the new rules, to make sure that the tax law will follow that.
Then a few words on what we see from clients, what are the typical motivations for cross-border reorganizations. So oftentimes it's a simplification of the corporate structure, sometimes in historical reasons, group-wide or a group with subsidiaries in many countries, they tend to get larger and larger. And we see quite recently a trend that this gets more lean and that the structure is narrowed down a bit. It may have reasons for restructuring the business. What we also see is that some groups are in the process of maybe dividing their sales business from the production entities, or establish competence centers, so that not each and every subsidiary has their own IT department, but that it's just a central department in one of the member states, and that's a reason why cross-border organizations could be used. It may have restructuring reasons, so that good assets and bad assets are separated. It could have optimizations from a regulatory perspective reasons, maybe if the industry is highly regulated and there is, I don't know, maybe passporting possible, that you just have a branch instead of a subsidiary, which might make things easier from a regulatory perspective. It's also a way to enter or exit the Austrian market, especially on the exit part. It's quite when we speak about maybe a cross-border merger, it's an alternative to a liquidation, and contractual partners may view a cross-border merger more beneficial, or this will be they don't think bad things other than if you say we need to liquidate this subsidiary. What we also see is prior to transactions, if either some part of the target entity is not acquired, or if a certain business unit should be the target and needs to be carved out from the rest, so just as a pre-transaction restructuring.
From an accounting or tax perspective, of course, there's also sometimes reasons for reorganizations. What I've seen in practice is that sometimes it's really like business driven or accounting driven, to make sure that the consolidation is easier, and that maybe to transform a foreign subsidiary into a branch to make corporate governance more easier. Of course, tax considerations can play a role. However, it should be made sure in practice that they are not the only reason for a reorganization, because, and we might come back to that, of course, there's always the risk that something is considered to be a tax abuse.
Yeah, then maybe a few words on the current legal situation. So prior to entering into force of the new law, a cross-border merger, there is, since 2007, there is an Austrian law, the EU Merger Act, which provides for the possibilities of a merger of two entities which have their corporate seat in two or more of the member states. The special feature is it's a very short law. I think it has 14 paragraphs, and there is a general reference to Austrian Stock Corporation Act and the Limited Liability Companies Act, and that's quite different from the new law, but we will come to that a bit later.
Yeah, tax-wise, cross-border mergers are also now covered by the Reorganization Tax Act, which will be discussed in more detail afterwards. So the Reorganization Tax Act generally provides for the tax neutrality of mergers. However, in the cross-border scenario, it could be often the case that Austrian taxing rights are limited in a certain way, which would lead to a non-neutrality of the merger or partial non-neutrality. But in general, cross-border mergers are possible from a corporate law perspective and are also covered by the specific tax laws.
On the cross-border conversion, so that's just another term for the change of the corporate seat of a company. That's not yet regulated by law, but at least in theory, it should be possible due to the case law by the European Court of Justice based on the freedom of establishment. The problem is that you always have to sit down with the judges from both countries. You need to convince the Austrian, if it's an outbound conversion, you need to convince the Austrian judge. You need to convince, for example, the French judge, because both of the jurisdictions need to play along. So this is possible, and yeah, that's a downside that it's not provided for in the law right now.
As concerns taxes, a cross-border conversion, so moving the seat from one country to another one, is not specifically regulated. I will come back to that also afterwards in a bit more detail. It's not a reorganization in a tax sense because no assets are transferred. It stays the same company, it stays the same entity, it just moves somewhere else. And in principle, the statutory seat, and this is just covered by the general tax rules and might have some tax effect or might have no tax effects at all.
Cross-border demergers, it's not, at least generally not possible so far. There are a few instances when practice tries to argue with the courts that it should be possible based on EU law and freedom of establishment. But at least I'm not aware of any case where anybody has been successful in convincing both countries that this should be possible. So basically, it wasn't possible until now. The typical workaround is that you do either as a first step a cross-border merger, and then in the destination country do a demerger, or you do first a national demerger of a business, of shares, whatever, and then do a cross-border merger into another country. So that was, or maybe it will also be in the future. We will come to that later. That this is the typical workaround.
Tax-wise, cross-border demergers are not yet covered under current law by the Reorganization Tax Act. So this was the biggest, or will be the biggest change in the Reorganization Tax Act to incorporate cross-border demergers. And basically what is the government bill so far and what has been the draft of the ministry is that the rules that have until now been applied to mergers will in a similar way be applied to demergers. So it's basically just the other way around. And so this is very does very much fit into the Reorganization Tax Act and was incorporated quite legally.
Yeah, this was the current situation up until now, and then showed overview of the EU Reorganization Act, so the new law. The scope of application: corporations may benefit from the rules in Austria. That's typically stock corporations and limited liability companies. If we exclude the European entity, the SE, not being a pure Austrian entity, but they may benefit from the rules as well. However, there are certain exemptions. The law says that it's if an entity collects public funds, so is an investment company in a broader sense, then it may not benefit from the law. Also, entities at the final stage of the liquidation. So when the distribution of the remaining assets has already started. So that's really the last stage of the liquidation. So after creditors have been secured, etc. So only in the latest stage, that's not possible anymore. Credit institution in liquidation and also in bankruptcy proceedings. There was quite a hot discussion topic, but it was decided that there should be no forum shopping, so that entities look out or reach out and look for the most beneficial insolvency laws. So that's not possible. Also, partnerships in general are not included, so it's really just corporations. From a geographical perspective, and yeah, thank you. I see that some colleagues from the UK and Switzerland are here, but it's only limited to the EU and EEA, so no third countries. For example, in an outbound situation, it's Austria, and the inbound country is one of the EU or EEA countries. From a timing perspective, that's not really clear. if and when the current rules are applicable and once the new rules will be applicable. In the draft to the Ministry of Justice draft, it was said that the decisive point in time is when the transaction document, and it's always called the conversion plan, the merger plan, or the demerger plan, when this document is signed. However, this provision is not in the final draft law as of now, and we will see what will be in there when it's final and published. But if let's say the rules will be the same, then the decisive point in time is the signing of the transaction document. So if this will be prior to 1st August this year, then it's the old rules, especially for mergers, because the other ones are not regulated right now. But if the transaction document will be signed after 1st August, then the transaction will be governed by the new regulations. And just that you just get a feeling for the importance, it's 70 cases per year right now, according to the ministry. In the future, there are 90 cases per year expected of cross-border reorganizations, all forms in which an Austrian entity is involved. Yeah, then what types of cross-border reorganizations are covered by the law? It's conversion, merger, and demerger. What is in very basic terms, what is a conversion? It's a company, a corporation in, for example, Austria, with a corporate seat in Austria, wants to move its corporate seat into another member state. And the crucial thing is that it stays the same legal entity. So it's, for example, it's an Austrian GmbH, and this will become the, I don't know, Dutch BV or Luxembourg SRL, and it's not like other than a merger. It will not cease to exist and become a new entity, but it will stay the same legal person. If you just look at the result, it's quite similar to a merger. You have a company in jurisdiction A, and then after the transaction, you have an entity in jurisdiction B, which has all of the assets, because a merger is universal succession. So every asset from in the middle column, every asset from ACO, assets and liabilities, will be transferred to BCO. So the result from the outset looks the same, but in detail, it may be beneficial to do either a conversion or a merger. Maybe if there are some contracts that require consent rights, or from a regulatory perspective, and yeah, it just on a case-by-case basis, you have to decide what is the appropriate form of the reorganization. A demerger, that's a bit different. In a demerger, it's just assets or specific types of assets that are transferred. In this case, we have a factory from ACO in, for example, Austria, that is transferred to another member state. And it's very important to understand, under Austrian domestic rules, there are basically two types of demergers. There's the demerger for incorporation, where there is just one entity right now, and with the demerger, the second company, so the acquiring company, comes into existence. And there is the demerger for absorption, so that there are, at the beginning of the transaction, there are two entities, but just the assets will be transferred from A to B. The second one is by far the most important in Austria, and that's the one that's not provided for in the law. So it will just be possible if there is not already a company in the other member state, but it will only be possible that it's formed by the demerger. So BCO in this example will be established through the demerger, but it's not possible if there is already a BCO to just demerge the assets. Germany, for example, they have managed to, at least for some cases, provide for a demerger by absorption in the law. And yeah, it will be very important in the future to just analyze what will be possible in both laws, because only then the transaction makes sense, because both judges, both courts need to come to the conclusion that it's possible. Otherwise, it won't work. So that's just as a basic hint that this needs to be assessed very carefully. On the structure of the new law, it consists in total of 71 paragraphs divided into 5 main sections. It's at the beginning general provisions and at the end final provisions, and then there is one main section for each of the types of reorganization, so cross-border conversion, merger and demerger. And in each of these specific sections, there is a systematic differentiation between or according to the direction of the reorganization. So there's always first provisions on outbound, sorry, and then on inbound. So that's a basic systematics of the law, that it's always tries to provide for specific rules for the kind of direction of the transaction. And in each of these types of reorganization, so conversion, merger, and demerger, and also for every kind of direction of the transaction, there are different levels of protection required for stakeholders. The stakeholders are typically minority shareholders, creditors, and public interest, and to a lesser degree, employees. The law only very particularly makes reference to the Stock Corporation Act and the Limited Liability Companies Act. And like I said at the beginning, that's a big change, because the current EU Merger Act, it has a general reference. If it's not provided for in the EU Merger Act, then Austrian law will apply. That's a bit different here. The legislator really wanted to provide for a complete set of provisions in this EU Reorganization Act. And the sections, the main sections are structured as follows. It begins with the cross-border conversion, which are described or provided for in detail. And then the provisions on cross-border mergers and demergers, they make just reference on the corresponding articles in for the cross-border conversion, and just provide for specifics for the respective type of transaction. And that's also how we want to present to you the 3 types of transaction. So we will do the conversion in a bit more detail, and just for the merger and demerger, just point out where are particular differences. Yeah, diving into the cross-border conversion. In general, it's the transfer of the registered corporate seat from one member state to another EU or EEA member state. And in accordance with the case Paul Butt, it's not required that also the place of effective management or that assets are transferred. It's really sufficient if it's just the corporate seat that will change. There are 3 main sections again, so it's the common provisions, the outbound conversion, and the inbound conversion. And it's clear that if you look at the chart, for example, Austria or each of your jurisdiction could be either the inbound or the outbound jurisdiction. So each local national law needs to provide for provisions on both directions. And typically the departure member state, so that's the member state where the company is existing right now, this member state assesses compliance with provisions protecting shareholders, creditors, employees, and public interest. And only afterwards, so the new member state, the destination member state, this assesses the compliance with registration requirements. So it's really important to understand that each of the 2 member states just looks for their provisions, and that's why it's really important to get counsel from both jurisdictions on board, because you need to comply with both laws. Then a few words what the cross-border conversion looks like in detail and what is required. It's basically corresponds to the current systematic of the EU Merger Act. So you need a transaction document that's called the conversion plan. It's set out in detail in the law what's need to be in there, and in practice that's how conversion plans look. So we have subsections for each of the items in the law, which we just describe what is required by law. And in one new item that was not in the EU Merger Act right now is that also subsidies the Austrian entity has received in the last 5 years need to be indicated. So that's just another, let's say, diligence item the companies need to look into, because this needs to be included in the conversion plan. Then there is the report of the management. This report is by law divided into 3 sections. It's a general section, it's a section for employees, and a section for shareholders. And if this report is required, depends on the specific circumstances. For example, if it's a sole shareholder, or if all shareholders agree or waive their right to receive such a report, then this section is not required. On the employee part, the law says if the company has no other employees other than the management, so the managing directors or the members of the management board, then also this section is not required. And then if both of these sections, so for the shareholder and the employee, is not required, then the report is not required at all. So it depends on the specific case, if yes, in which detail this report of the management is required. There's a report of the supervisory board if there is a supervisory board, and if the shareholder does not waive its right to receive such a report. There is an audit by an auditor. Again, this could be waived by the shareholder. Then the intended conversion, so basically the conversion plan and corresponding or accompanying documents need to be published. And that's another difference from the EU Merger Act right now. What we typically, and what is typically market practice in Austria, is that the documents which also now need to be published, they are published in the Austrian edicts database, or Edichtsdatei, which is not possible anymore. So it's mandatory that the documents are filed with the court. Reason behind is that courts are in other member states, they are interconnected, and if you file the documents with the Austrian court, for example, this can be accessed by the courts in Germany, France, Spain, etc. So that's why documents need to be filed with the court. Then there is the resolution of the shareholders on the conversion. That's a qualified majority requirement of 3/4 of the represented capital at the general meeting. Which may not be made less strict in the articles, but the articles may provide for stricter requirements. Then, after this resolution has been passed, there's the filing with the court, the Austrian court. The Austrian court reviews the intended conversion, inclusive, and that's a main new feature. There's an abuse assessment or abuse test, but we will come to this one a bit later. If this comes out clear, and if the Austrian court says yes, all is in compliance with Austrian law, then they issue a pre-conversion, or in other cases a pre-merger or pre-demerger certificate. Then the conversion may be filed with the agency, court, or authority, whatever, in the destination member state. And then this member state, they assess these local requirements for the conversion. And if everything comes out clear, they will register the conversion. The effective date will be, or the registration in the destination member state is the decisive date for the effectiveness. Again, the destination member state will notify the departure member state, and the company will be deleted from the Austrian commercial register. A few words on timing. The law provides for several deadlines and timelines that need to be adhered to. The first is that for the convocation of the resolution, or for the general meeting, there is a 6 weeks deadline. Another one is that between or prior to the date of the general meeting, at least 1 month prior to that date, the publication of the the intended conversion needs to be published with the court. And then another one is that between the publication of the intended conversion and the filing with the court, there is, at least de facto, there is basically a 3 months deadline due to creditor protection rules. But again, we will come to this a bit later. Speaking of creditor or in general protection of stakeholders, it's very different to understand that for each and every of the transactions, so conversion, merger, demerger, there is a different level of risk to the different stakeholders. For example, in a conversion, what happens in a conversion? You have now maybe a limited liability company in one of the member states, which will become a limited liability company in another member state. So if you are a creditor and you have your contract with the company, the governing laws from this contract and the contract itself, it will not change. The only thing that will change is the corporate law governing this company. So for example, if it's an outbound conversion and your agreement is with the Austrian GmbH and it will become a Dutch BV, you have the contract with the Dutch BV. And the risk is that the corporate law may provide for a different level of protection for creditors. Most notably in Austria, we have very strict capital maintenance rules. And if you just look to Germany, they also have creditor protection rules, but they are less strict. For example, in Austria, the whole assets are protected and may not be distributed to the shareholder. In Germany, it's just the share capital that is protected. So if I am a contractual party to a GmbH in Austria, I know that this company may not distribute assets to its shareholder. But after the conversion, I cannot be sure because maybe I, as a creditor, don't know the local laws, and there is at least the potential risk that my claims are, that I cannot assert any claims, or that's not the same level of protection. For minority shareholders, the problem, I will stay a shareholder in then the foreign company. Again, the corporate law of the company changes. This may have consequences for example, the duties of the management board or the supervisory board. So I know as a creditor or as a shareholder, I know what needs to be complied with by an Austrian managing director, but I don't know if it's the same level of duty in another member state, and that's my problem as a shareholder. And there's also the public interest, which came into the law only with this new law. To address these risks, the new law provides for several mechanisms. In the outbound conversion, creditors in Austria have the entitlement to ask for collateral if receivable is at risk. New is that these claims must be filed with the court. The deadline is 3 months from publication of the intended conversion, so after filing of the intended conversion with the court. On the level of evidence, it's the creditor needs to be credibly evidence his or her claim, the fact that the claim is not yet due because he asked for security, and the endangerment of the claim. And important to note is that the court issues the pre-conversion certificate. So that's the certificate that everything is in compliance with its own law only after expiry of the 3 months deadline for asserting this claim. And if claims have been asserted in time, so within this 3 months, the pre-conversion certificate is only issued following securing of the creditor. So in practice, this means that there is at least a risk, or there is a blocking potential for creditors, because if a claim is asserted and this is not resolved in a very fast way, then the member state, the outbound member state, will not issue this certification, and and without this certification, the destination member state cannot register the transaction. So that needs to be, yeah, we will see how and what will the process will look like, and if this will be a problem in the future. On minority shareholders, so if I'm not happy with the decision by the majority shareholder that an Austrian stock corporation will be converted into a German stock corporation, then I have the right to exit the company. So there is in the conversion plan, the company needs to offer an appropriate cash compensation, and this is an offer to the minority shareholder which can be accepted by the minority shareholder, and there is a subsequent procedure to review and test this appropriateness in court. And a court decision, if the court comes to the conclusion, yes, this was not appropriate, it should be higher, then this has effect for all shareholders. On the public interest side, there is this new abuse examination of the Austrian commercial court in an outbound conversion situation. And the provision in the law says that the court must also examine whether the conversion is carried out for abusive or fraudulent purposes which lead or are intended to lead to the evasion or circumvention of union or national law, or for criminal purposes. And the court shall refuse to register the intended conversion where such purposes exist. This is also the background of this new provision, and this needs to be included in every local member state because this is a requirement by the directive. The reason is that member states, because as I mentioned, Paul Butt in the case law, the European Court of Justice confirmed that it's okay to just change the corporate seat without changing the management or any assets. And member states feared that this will be used for abusive reasons. And that's why in the legislation process on EU level, this came into directive that each member state needs to or must provide for these abusive tests. Since it's quite unclear, Austrian law at least provides two hints what is meant with this. It says that if a statement has been entered into the commercial register that the company is a fictitious company, it must be assumed that the conversion is being for abusive purposes. In the last 7 years, I've never came across a company that has registered or that was registered as a fictitious company. So I think that's not really practical, this provision. The second provision is that if the company submits to the court a tax ruling pursuant to the Austrian Federal Fiscal Code, in which the existence of abuse under tax law is denied, then no abuse is to be assumed in this respect. I think Karin will come to that a bit later on this filing and on the importance of this filing. Just if you look at the feedback of courts and judges, they all have a really big problem with this provision. The statement was, we have not enough judges to do this examination. We have no experience with abuse control, and we don't know what this will look like. So this will be since it's new for the commercial register courts. We will need to see what the courts make out of this provision. Then a short overview of the timeline of a cross-border conversion. So it all starts with setting a conversion effective date for accounting and tax purposes. Oftentimes, because annual accounts can be used, this is the year end. So let's assume it's 31st December 2023. Then the law sets a 9-month filing deadline in the outbound jurisdiction. So in case of an outbound conversion in Austria, that's 30 September 2024. Within this deadline, the intended conversion needs to be filed with the Austrian court. Assuming the client and we manage to file by mid of August, Then the court, and that's also new, has a 3-month review period of the intention to make the conversion. It's stated in the law, if this 3-month period is not enough to do the abuse test, then this 3-month review period can be extended by another 3 months. So we are at the mid of February already. And then the law says, even if this extended period is not enough to do a final assessment on this abuse assessment test, then the company needs to be notified about the reasons. So it's just a notification obligation that is complicated and that the judge needs more time, but there is not a definitive end to this review. So it's basically an unlimited period, and it's just the Austrian side of the thing. We also need to bear in mind that the destination member state needs to do its review, and it will depend on local laws if the whole procedure in, for example, Austria will have to be finished until it can be filed in the destination member state, or if these two procedures can work in parallel. This would be the case in Austria. Austria, if you look at the inbound provisions on the conversion, it just says that it's not the pre-conversion notification from the other member state in the inbound case is not mentioned as one of the items to the filing. And also it's just said that the conversion in Austria in an inbound structure will not be registered until the other member state has issued this certificate. But it does not say that a filing is only possible from this point in time. So at least in my reading of the law, it could be possible that these two review periods in both member states work in parallel. Yeah, up to you guys.
Oh, thank you, Chris. I will go into a bit more detail on this possibility of a binding ruling for tax abuse. As you have mentioned, the court actually in the future also has to examine whether there is any abuse, any abusive situation. This is not true only for the conversion, but also for the other types of reorganizations. Now that we go into the tax area, I encourage all the attendants again, if you have any questions, please put them into the chat. We will try to address them. So there is the possibility of a binding ruling under Austrian tax law for specific areas, one of them being if there is tax abuse. And the law now says, so that's the corporate law, that if you have such a binding ruling that excludes any tax abuse, this has to be considered by the court. So the thing is that this binding ruling is of course not mandatory. It also doesn't say if you have like a negative ruling that you have to present it to the court, but we expect that courts might ask for such ruling more and more, because of course, how should the judges really examine whether there is any tax abuse? They're not trained for this. And so if I remind you of the last slide presented by Chris on the timing, you have to make sure if you have to bring such a ruling that this also takes a couple of months, ideally just a few months, but that would add to the 6-month period. So it's really to be seen how this will work out in practice. Something that is also very interesting is that in such a tax ruling, the taxpayer presents facts of the case that are not yet realized. So you say you're going to do a reorganization, how is that going to happen? But the tax office that issues the ruling doesn't examine the facts of the case. So it just says, so if these facts of the case are done as you described, this will be the tax consequences. But of course, the court, if they issue this pre-certificate for a reorganization, they have to make sure that the facts presented in the tax ruling are actually the facts that will be implemented. So this is going to be very interesting to come. So for sure that those binding tax rulings will be more and more coming. The abuse rulings as of now are only very few. Now we dive more into the tax issues, and a bit as a starting point for all of those of you who are not tax lawyers or experienced in the field of tax law. With tax law, you always have to make sure is any tax law taxing right of Austria, in our case, limited by this reorganization, or does a new taxing right arise? And here I just want to quickly note something on the OECD Model Tax Convention, which is the model for most of the bilateral double tax treaties that exist. And here we have three important rules. The first one of them is, what is a tax resident company? Well, this is typically defined by the place of effective management of the company. So there has been a revision in more recent versions of the model convention, but in most tax treaties, still the place of effective management is the deciding criterion for determining which is the country of residence of a company. Business profits generally can be taxed in the state where the business, where an entity is, has its seat or its place of management, unless there is a permanent establishment in another state. Permanent establishment could be typically a branch, could also be a construction site. But make sure to remember that the state of the permanent establishment has taxing right. And with regard to capital shares, it's typically only the state where the shareholder is resident that is allowed to tax any capital gains in the shareholding. So this is important for figuring out the tax consequences of the conversion, as we're discussing now. So, as I've mentioned in the beginning, a conversion is not really a reorganization in the sense of the Reorganization Tax Act, because no assets are transferred between two taxpayers. The more, if there is only a change of the statutory seat, as Chris has said, that this is like the main idea of the conversion, changing only the statutory seat of a company, this has typically no tax effects at all. If we think of what you see here on the right side, a company, an Austrian company, moving its statutory seat to, let's say, Germany, with its place of effective management or place of management still being in Austria, this will have no effect at all, because it will stay company subject to unlimited tax liability in Austria, and it will also be tax resident of Austria under the double tax treaty with Germany. So tax effects typically only arise if the place of management is also transferred to the other country. And also you have to differentiate, as you see here in my drawings, what are the assets of the converting company? Is it a holding company? Does it have only like shareholdings? Does it have a business in Austria? Does it maybe have permanent establishments in other countries? I have here included quite a simple example of an Austrian entity with an Austrian business operation and the shareholding in an Austrian subsidiary. And if this entity moves its place of management and statutory seat to Germany under the new rules, Austria will lose its taxing right for the capital gains in the shareholding. So this would be the shareholding of BCO in CCO. It would, however, not lose its taxing right for the profits of the permanent establishment. So with regard to the capital gains in the shareholding, where the Austrian taxing right is limited, Austrian exit taxes would be triggered. This is not under the Reorganization Tax Act, but under the General Tax Rules, which are included in the Income Tax Act, General Tax Rules on exit taxes. Coming to the next slide, I give back to Chris.
Yeah, thank you. In this scenario, it's the inbound conversion. So the other member state is the departure member state, and Austria is the destination member state, and it's quite the same procedure, just the other way around, let's say. And from an Austrian perspective, the thing to note is that now Austria just looks at the risks for the new creditors once the entity has been converted into an Austrian, let's say, GmbH, and this is done by a foundation audit in accordance with the Austrian Stock Corporation Act rules. Why? Because, you know, in the conversion scenario, the new company is not established with cash, but it's like an in-kind incorporation, and the Austrian court and also an external auditor, they have to assess if the share capital of the then Austrian entity amounts to at least that the assets of the company amount to at least the share capital. That's just a creditor protection rule. That's just, yeah, that's the second step if it's an inbound conversion from an Austrian perspective. Otherwise, it's just the other way round. So the procedure will take place in the other member state. The other member state will issue this pre-conversion merger demerger. It's the same procedure basically for every transaction, and only Austria will then assess its local Austrian rules, and in particular protection of new creditors.
Okay, so then we come back to the tax rules concerning the inbound conversion, and just to be very quick here, in the interest of time, you have to, could you maybe go to the next slide, Chris? Yeah, I can do that now, thanks. So here it's the other way around again. So you, in the inbound case, Austria will give a step up for the assets where the Austrian taxing right arises, which is again the capital share in CCO. And just to make sure that all the capital gains that have arisen while there was no Austrian taxing right will be excluded from Austrian taxation. At the shareholder level, of course, you also could have certain exit taxes or a step up in the inbound case, just to make sure whenever there is on the shareholder level of the company that is moving, when there is a limitation of the taxing right, could be maybe if it's a non-EU shareholder without a double tax treaty between Austria and its state of residence, that exit taxes also rise at the shareholder level. So now we go to the next type of reorganization, the cross-border merger.
Yeah, thank you. Like I said, the conversion is the model, and the merger and the demerger closely follow this model, and just the law provides for some specific requirements to this transaction type. The cross-border merger, it follows in principle the cross-border conversion and also the current EU Merger Act. So that's already tested law in Austria. The special features or deviations from the current EU Merger Act, that's the longer deadlines, particularly in because of this abuse test, because this is new, like Karin and myself said, this could take a few months until this comes to a conclusion and assessment. And in comparison to the EU conversion, what's different is that you don't have only the exit right of minority shareholders, but if a shareholder, minority shareholder of the transferring company decides to stay a shareholder in the new company, become a shareholder in the new company, and not make use of its exit right, then such minority shareholder has the right to get the exchange ratio examined in court, and it's also, yeah, it's a court proceeding in an outbound scenario in Austria, and the problem or what needs to be seen in practice is that also the shareholders of the receiving company in the other member states, they have, or they should, according to the directive, have the same right, but they will need to file their claims with their local court. So it may well be that Austrian minority shareholders are not happy with the exchange ratio, and that the other shareholders are not happy with the exchange ratio, and both the shareholders in both jurisdictions claim their local courts. And yeah, it's not clear if the outcome will be different, what will be the consequence of this.
Yeah, I'll take over with tax rules on cross-border mergers. If you could just, I'm switching to the next slide. So again, with tax you have to differentiate, is it an outbound or an inbound merger? What's important here is that the prerequisites for the tax neutrality of a merger are threefold. First of all, the merger has to be admissible under company law, which was possible for a cross-border merger under the old law and also the new law, of course. To apply the rules of the Reorganization Tax Act, you have to have no restriction of the Austrian taxing right for the latent gains and the goodwill in the assets at the level of the absorbing entity. So here, if you merge an Austrian company into a German company, similar as with the conversion before, you will typically have a restriction of the Austrian taxing right with regard to any capital shares that are transferred due to the merger. Two things are important here. You can have a partial tax neutrality under the Reorganization Tax Act. So you would have tax neutrality regarding the assets where the Austrian taxing right is not limited. And as far as the Austrian taxing right is limited, you will not have any tax neutrality. Any exit taxes that are triggered can be, if it's a merger to EU country, or also EEA. So all that's possible under the new law, you can pay any tax that arises in installments. The third requirement is that the merger is not abusive. So as you can see here, there is an anti-abuse rule in the Reorganization Tax Act, so an own tax abuse rule. So basically, also as of now, without the new corporate law, it always has to be made sure that a merger is not abusive. If it was considered abusive by the tax authorities, then the benefits of the Reorganization Tax Act would not be applied. With regard to the inbound case, we again have a step up to the market value of any assets for which the Austrian taxing right arises. So this would be inbound cases, let's say an inbound merger from another EU country to Austria. At the shareholder level, we have specific rules for mergers that are different than the ones I've mentioned for the conversion before, because whenever we have no restriction of the taxing right at a company level, so let's say there is a merger of there's an outbound merger and there's only permanent establishment and no restriction of the taxing right. You would also have no taxation at the shareholder level, no matter whether there is any separate restriction of the tax right at the shareholder level or not. So whatever happens at the company level is decisive for the shareholder level taxation. Moreover, even if you have such a restriction of the taxing right, and the shareholders are resident in the EU or EEA, there will also be no taxation. So you see that the merger, to some extent, can be more beneficial, more tax beneficial than a conversion. On the other side, if you have, if the taxing right arises at the shareholder level, there will be no step up under the reorganization tax law at this level. And then, last but not least, we come to the cross-border demergers. Chris, please.
Yeah, thank you. Like I said, also the demerger follows the. Sorry, just the next slide. It will come. Also the cross-border demerger will follow the conversion mechanics, and I just wanted to point out two important points in a cross-border demerger. The first is, like we said, it's not possible to do a cross-border demerger for absorption, and that's by far the most important transaction structure in case of a demerger in Austria. So the practical relevance of a cross-border demerger, if that's not possible, we will have to see if it will be of practical relevance, or if we need to do the workaround also in the future, even if there would be provisions on a cross-border demerger. And the second one is the protection of creditors. That's of importance of a demerger, because from a creditor perspective, if I am a creditor of an Austrian company and the Austrian company demerges its most important assets to another company, and I'm not part of this demerged assets, and my contract stays with the transferring company, then the capital and the funds available to my contractual party will get diminished, and there is a risk that I may not be satisfied, or my claim may not be satisfied. And the special thing is that the Austrian concept to address this risk, this doesn't work in a cross-border demerger scenario, because the capitalization of the acquiring company is not governed by Austrian law. So the typical protection mechanism, the Summengrundsatz in Austria, this doesn't work because it depends on the rules of the destination member state. And therefore, the law provides for the provision that the share capital of the transferring company, including its restricted reserves, is to remain the same, and that a reduction of the share capital is only possible by way of an ordinary capital decrease, including all the creditor protection rules under Austrian law. There's also a residual asset audit. We know this from domestic Austrian demerger law. So there needs to be an expert appointed, an auditor, which confirms that the value of the residual assets staying in the transferring company amount to at least its share capital, including restricted reserves. And there's also the demerger liability, like in the Austrian Demerger Act, for all involved companies in the cross-border demerger.
So coming back to tax law, as I said in the beginning, the rules that are now to be incorporated in the Reorganization Tax Act for cross-border demergers resemble very much the rules that we already have for cross-border mergers. So now this will be possible under the Reorganization Tax Act. What is very important with regard to a demerger, you have to have a transfer of qualified assets. So this could be business units, partial business units, partnership shares, or capital shares of more than 25%. So you have to have one of those assets has to be demerged in order for the Reorganization Tax Act to apply. Otherwise, very similar rules as the demerger. There has to be no restriction of the Austrian taxing right. Otherwise, with regard to EU and EEA, you can pay the exit tax triggered in installments. And there's also the possibility for partial tax neutrality for the cross-border demergers. Same with regard to the inbound case. You will have a step up to the market value with regard to assets for which the Austrian taxing right arises. Last but not least, the shareholder level. Again, same rules as for the merger, and there has been a change. If you're familiar with the draft laws, a change between the draft from the ministry and the government bill. Also now for the demerger, if you have a restriction of the Austrian taxing right, but the shareholders are resident within the EU or the EEA, there will be no taxation at the shareholder level. Again, there's particular rules for certain types of restructurings, mostly within a group. And again, there will be no step up at the shareholder level, even if the Austrian taxing right arises at this level. A very last note from my side with regard to the now possible division by separation. So I would call it a spin-off under corporate law. So whenever there is assets spun off, but the shares granted are not given to the shareholders of the demerging entity, but to the demerging entity itself. This is basically a contribution under Austrian tax law. So it's not in the Reorganization Tax Act a demerger under Article 6, but it will be treated as a contribution under Article 3. And that's very important because this has quite different and maybe more prerequisites for application of tax neutrality. I put it on the slide here for an overview. So you also have to have qualified assets. You also have to have a qualified receiving corporation, which is an EU corporation covered by the merger directive, for example. But what is very important, what you can do under corporate law is you can demerge assets under this rule to more than one receiving or absorbing entity. And each of, if you want to apply tax neutrality, each of those spin-offs has to include qualified assets and go to a qualified receiving corporation. Also very important for the tax neutrality to apply, the assets must have a positive market value. So this is something that is particular in the rules of the Reorganization Tax Act. Other than that, I think the time, there's no time really left to go into more details. The really important thing to take away from here is that this type of reorganization is not a demerger under the Reorganization Tax Act, but a contribution. Going to the next slide, I think Chris will talk a bit about the consequences that we expect for the practice.
Yeah, just thank you for bearing with us. Just a few what we think will be the most important consequences. It's important to verify whether the provisions of the directive have been implemented in both countries the same way, or if both transactions are possible in both or more of the jurisdictions. We expect that the duration of reorganizations will be prolonged. So, and particularly because of this new abuse test and assessment, like we said, it's 3 + 3 months, and then basically an unlimited period of time. Let's see what practice brings. A binding tax ruling might be required by a court. It's not, let's say, required by law, but for practical reasons, if you expect or if you intend that the certificate by the outbound member state is issued in a very fast manner, then it might make sense to just obtain the ruling and to provide it to the court. It's important that counsel from both jurisdictions are involved, because you always have 2 or more EU member state jurisdictions, and the local rules need to be complied with from both countries. The most relevant type of demerger, namely the demerger by absorption, that's not provided for in the cross-border scenario. So it's not clear yet if the workaround will still be required, or maybe there's still a change in the law that this will be provided for. That needs to be seen. And also some details are not yet clear, like the review of the conversion rate in case of a cross-border merger. If 2 courts in 2 different jurisdictions review the price and come to a different conclusion, that's not clear and not in the law what would be the consequence of this. Yeah, thank you. That's it from our side. I think I have not seen any questions in the chat so far. I think you will receive the recording and the presentation afterwards. So if you scroll through the presentation once again, and if some questions come to mind, just write us an email. Happy to discuss and provide our thoughts. Yeah, that's it from me. Karin?
Yeah, thank you very much for listening. I hope you got a good overview of the rules to come. As Christy said, you find our contact details, I think, on the second slide of the presentation, which you will receive latest Monday, and also the recording. So if anything comes up, just drop us a line or give us a call, and we'll be happy to discuss. Otherwise, I think just saying thank you very much again for joining, and have a good rest of the day. Goodbye.
Thank you. Bye-bye.